Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. The topic of today's program is the ARD program through the York County District Attorney's Office, and my guest is Katie Romeo, who is the ARD administrator for the District Attorney's Office. So welcome, Katie.
Thank you.
And my very first question is, what is the ARD program?
Well, ARD stands for Accelerated Rehabilitative Disposition, and that's why we stick to calling it ARD. But it is a pretrial diversion program for first-time, low-risk offenders. The program is designed to divert offenders out of the criminal justice system by means of rehabilitation, addressing underlying issues of crime.
So Accelerated Rehabilitative Disposition. It's a mouthful, and
yes,
everyone calls it ARD.
Yes.
But basically, as I understand it, and I don't handle any type of criminal cases, but as I understand it, basically it's something where someone charged with a relatively minor offense can go through a program so they do not wind up with a criminal record.
Correct.
Does that summarize it
Yes.
nicely?
Perfectly.
But there's a lot to the program,
Yes.
and you administer how it works,
correct?
So let's start at the very beginning. Someone is charged with a crime. There are only certain types of crime where someone would be eligible to get into the ARD program. Is that correct?
Yes.
And can you give an example of types of crimes where someone can get into the ARD program?
Sure. Well, 70% of our caseload is DUI offenders. So first-time DUI offenders are a perfect candidate for ARD.
So DUI, driving under the influence, drunk driving, basically.
Correct. Yes. On top of DUIs, we also have non-DUI offenses, which would be offenses such as retail theft, theft by unlawful taking, simple assault, misdemeanor offenses of relatively low nature in crime.
Okay. Most of these crimes would be misdemeanors as opposed to felonies?
Correct.
And I understand there's a list of crimes where there's absolutely no right to get ARD.
Correct. There is a list of what we consider mandatory exclusions, which are offenses that are inappropriate for ARD, and they're primarily felony offenses.
So the more serious crimes, someone would never be able to get into the ARD program.
Right, like your rapes, your robberies, those kinds of serious offenses.
Okay, so this also, you indicated, is something for first-time offenders. But I understand there are exceptions.
Correct. Ideally, it's first-time offenders. It's not limited to, if an offender is going to apply for ARD, ideally they have a minimal prior record and not an extensive prior record.
Okay, but ideally the candidate will most likely be accepted if they never committed any crime before.
Correct.
And that's one of the criteria to get into the program. And for the few cases where someone had a prior record, it's usually something that was minor and many years ago.
Correct.
Okay. I believe you told me before the program began with a DUI, it had to be more than 10 years ago. Is that?
Per statute, there is a restriction. If you've had a DUI within 10 years, the statute says you're not eligible for ARD. Now, if you've had a DUI offense outside of the 10 years, we would consider it and look into it and determine, essentially the district attorney would determine whether you're an appropriate candidate.
Okay, and you're the administrator for the program, so what does that involve?
Many things, but ultimately I oversee the ARD program in terms of overseeing the 2 support staff that are within the ARD unit. I also oversee the applications that are coming into the district attorney's office.
And can you tell us how many applications you receive in a typical year?
Approximately 3,000 applications.
So, and you have to go through these applications to determine whether or not someone is eligible to be in the program.
Correct.
And approximately how many people are accepted into the program each year?
Approximately 1,700 offenders are accepted each year.
Okay. Now, if somebody is accepted into the program, to begin with, how do they apply for the program?
Well, at the preliminary hearing, which is essentially the first step in the criminal justice proceedings, they choose to waive their preliminary hearing or they hold their preliminary hearing. In our county, in York County, we do not require them to waive their preliminary hearing. But at that step, they would request an application at the Magisterial District Justice, and they would fill that application out in its entirety. It's on a bright orange piece of paper, and once they've filled that out, they will submit it to the District Attorney's Office, either dropping it off or through the mail.
Okay, now the preliminary hearing is, as you indicated, is the first basically court proceeding.
Correct.
In a criminal case?
Yes.
And that's typically held at a district justice office?
Right.
Where the district justice decides whether or not there is enough evidence against the defendant to proceed to trial?
Yes.
And you indicated that I can have my preliminary hearing and maybe the district justice will throw out the case, but if the district justice does not, then I can apply for ARD.
Correct.
In some counties, though, you have to waive the preliminary hearing and to qualify for ARD.
Yes.
But not in York County.
Not in York County.
Okay. So someone goes to the preliminary hearing, whether they waive it or not, are they given an application?
They have to ask for an application. The staff has applications there. They're not going to give it directly to them. They would have to say, I'm interested in an ARD application.
So many people bring an attorney to the preliminary hearing. The attorney would know this.
Correct.
But if someone goes without an attorney, it's incumbent upon them to know that they should apply for ARD.
Yeah, and actually the Magisterial District Justice sends out a packet of paperwork to offenders that includes a document that says, is ARD for me? So they've been notified of what the program is, and they, on themselves, if they're representing themselves, can request that application there.
Okay. Is it necessary for someone to have an attorney to help them apply for ARD?
It's not necessary. It's not required for you to have an attorney. I do recommend it if you're not familiar with the criminal justice process or your rights. It's always helpful to have an attorney to turn to ask questions. You can certainly proceed on your own, but an attorney would be helpful.
Okay. And after you complete the form, is it just mailed to the district attorney's office?
Yeah, they can mail it or drop it off, but they can't fax it or scan it. We need it to be on the original copy.
Okay. And then what happens?
Once they submit the ARD application, assuming they apply for ARD at the time of their preliminary hearing, the next step would be their formal arraignment. That's typically 30 days out from their preliminary hearing. If a defendant is representing themselves pro se, they must show up at their formal arraignment. If they have an attorney, their attorney can choose to waive that arraignment and they would not have to appear, and then essentially they're waiting to hear from our office as to whether they've been accepted or rejected.
By the way, I believe you indicated that there's a website that can help people learn about ARD and what they need to do to apply and what the criteria is. Can you give us that website?
Yes, it's yorkda.com.
Okay, and you can go to, what is there, a link to ARD program?
Yeah, at the top of the page there's several links, and one of them is ARD program, and it will give you specifics on the program, procedurally speaking, our point system, and then just a little bit of what the ARD program is.
Now, you indicated that you have about 3,000 applicants a year, and you accept about 1,700. Mm-hmm. What makes someone eligible?
Eligibility in your county, because it's different in every county, because it's based solely on the district attorney's discretion. So in your county, our DA, Tom Kearney, has established a point system for determining eligibility into the program. And essentially this point system serves as a guidelines for determining eligibility, but also it assesses various points. Or it assesses points to various components, such as your prior record, your current offenses, and your current summary offenses. The idea of the point system is like a 3 strikes and you're out. If you exceed 3 or more points, you're not qualified, you don't qualify, and you'd be rejected from the program.
All right. Well, you gave 3 issues: prior record, present offense, the one you're being charged with now.
Correct.
And the third was prior summaries?
Or current summary offenses. Yes.
Summaries. What's that mean?
That would be like traffic violations. We assess points to driving under suspension, driving without insurance, offenses that are summaries in nature but still would count for your driving record and things like that.
Okay. And there are also other people that are contacted to get input into whether or not someone should get into the ARD program. Is that correct?
Correct.
And who are those people?
We contact the police officer. The affiant in the case gets an opinion on ARD. We contact the victims. All victims in the case have an opinion. And the prosecutor that is handling the case in the district attorney's office will weigh in on their thoughts.
So if I was the victim of a minor crime, let's say you said shoplifting was, and I own the store where the shoplifting occurred, I could say, I don't think this person should get ARD.
Absolutely.
And I am asked. That's part of the criteria to determine that.
Yes, we are required to notify victims.
And you're not bound by the victim. Is that correct?
That's correct.
It's just 1 point if the
Correct.
victim says no.
Essentially one strike, yes.
One strike.
Yes.
Of the 3 strikes, you're out.
Yes.
And the arresting officer is another person who has the opportunity to make a strike.
Correct.
And the prosecutor, him or herself, has the right to weigh in on it?
Right. And if they recommend the defendant for ARD, they would lose a point. So it would count in their favor if the victim, prosecutor, or the police officer were in favor.
Okay. Are different offenses given different weight?
As far as those...
When you said one of the criteria in the point system is what the present offense is.
Yes.
Like is DUI more than shoplifting, or I don't know which...
Not necessarily, but we assess if you're applying on a felony charge, you're automatically got 3 points. So you would have to have a victim, police officer, or the prosecutor be in favor of it to knock you down to 2 points and put you in the eligibility.
I see. So, and you indicated before that this is discretionary with the DA.
Yes.
But at the same time, the DA, instead of saying, I like you, I don't like you, so I'll give it to you and I won't give it to you, has set up criteria to be basically fair.
Absolutely.
To the applicants.
Yes.
And you're the one who monitors that system and counts the points.
Yep, and I communicate with him on those cases that are borderline eligibility. If there's red flags, if they have an extensive driving record or there's something egregious in nature in the charges, I will bring those to the DA's attention.
And with respect to the victim's input, I understand that there are special people, victim advocates. I don't know what they're called, quite frankly,
Yes.
but there are people who contact the victims. It's not your job to do so?
Yes, we have victim witness coordinators in our office who have all
coordinators. So
all victim contact.
But anyway, they're the people who will contact the victim, speak to the victim, get input from the victim.
Yes.
Okay? And then you take all that information. Some of them are clear-cut. They're either eligible, they're not eligible. Some are on the borderline.
Correct.
And then you meet with the district attorney,
Yes.
Tom Kearney?
Yes.
And the two of you decide together what?
Ultimately, it's his decision, but I go over the workup that's been done as far as what the points consist of, what the case is about, the facts, and then he makes a determination as to whether they are accepted or rejected.
I would believe from the criteria you set up that there are very few borderline cases. Am I correct on that?
You'd be surprised. I mean, we take them on a case-by-case basis. So the point system is great because it serves as a guidelines, but we're also looking at each case on an individual level.
Okay. That's good. So then if someone is put into the ARD program, they don't just say, okay, congratulations, you don't get a criminal conviction. There's a lot they have to do. Is
Yes,
that correct?
that is correct.
And the first step, I believe, is they have to go to a court hearing.
Yes.
Does the judge have any say in whether or not the person is accepted into the ARD program?
Yes, the judge is the ultimate signer of the court order. So if he doesn't believe that that candidate is appropriate, although it's the district attorney's discretion, he can refuse to sign the order and deny them entry into the program.
So the judge who's overseeing the case, and my understanding is after the person gets notification they're accepted into the program, they go to court.
Yeah, we schedule them for an ARD placement
The judge
hearing.
can, on his or her own, deny the ARD. Is that?
That's correct,
That
yes.
is correct.
It very rarely happens, but...
It really can it be the other way around, where the judge says this person should be an ARD even though the DA said no?
No, not
You haven't
necessarily.
seen that
No.
happen. Okay. We're almost out of time in the first half, and we'll be back after these words. Thank you. Welcome back to Legal Lines. My name is Tom O'Shea, the host of this program. My guest today is Katie Romeo. Katie is the ARD administrator for York County's District Attorney's Office. And we were talking about ARD, which stands for Accelerated Rehabilitative Disposition.
Yes.
And as we talked in the first half of the program, this is a program for basically first-time offenders, for less serious crimes, low-risk offenders who can go into a program so they do not have a criminal record for their first offense. Is
Correct.
That
yes.
I
a
know
good
it's a lot
synopsis.
more complicated than that, but that's a summary of
Yes,
it. Okay?
very good.
Thank you. And we were starting to talk about once someone applies for the program and how they get accepted into the program. Now I want to talk about what happens once someone is in the program. What do they have to do?
Okay. Well, once they're placed onto the ARD program, they have specific conditions that they must abide by while on supervision. And those conditions are specific to the offense. Let's take a DUI offender, for example, because that's the majority of our caseload. A DUI offender is going to have conditions such as 12 months probation, 35 hours community service. They're going to have to complete a drug and alcohol evaluation, and they will have to comply with the recommended treatment. They also have to do DUI education classes, attend a victim impact panel, and they will have to surrender their license, which the time frame for that is based on the tier or the gradation of the DUI.
In other words, the content of the blood alcohol?
Correct, yes.
So the higher the blood alcohol, the longer someone would lose a license.
Absolutely, yes.
So even though they have to be on probation, even though they lose their license and have to do the community service, if they complete these things successfully, they do not get a criminal record.
Correct.
Okay? Now, it sounds like some of these programs have costs involved.
Yes.
Okay, what would it typically cost someone to go through the ARD program?
On average, it's anywhere from $1,500 to $1,800, and there is an administrative fee for ARD. I believe it's $375 for DUI offenses and $325 for non-DUI offenses. And then their court costs are everything included in normal court costs, which can be very expensive.
And if there was a victim of the crime, like it was a shoplifting, let's say, or someone with a DUI did some damage to another car or a piece of property, there would be restitution as well?
Yes, restitution on top of what their court cost is.
Okay, so in some cases it could be several $1,000s.
Yes.
And this is not including the legal fees that they would have if they have an attorney who guides them through the ARD program.
Right, legal fees would be separate.
Okay. So there are some serious costs involved to get into the program. And once they're in the program, what happens? They get a letter that says, okay, you qualified for the program. Now they go to a court hearing. The judge has to accept it.
Correct.
And then what happens?
They're officially placed on probation effective the court hearing.
And there's a probation officer that they would have to report to?
Yes, there are specific probation officers for DUI offenders and then non-DUI offenders as pertaining to ARD. And once they're placed on ARD, they have that 12 months probation to complete all of those terms of their probation. And then they simply communicate that with their probation officer and provide the proof of everything, proof of all of the conditions. And then if they can complete those conditions, the probation officer will close their case.
So do they have to meet regularly with the probation officer?
They don't necessarily meet regularly. It's not regular reporting like you would on general probation, but they can be called in to the probation department.
And is there any other court appearance after being approved into the program by the judge?
No, once they're at their ARD placement hearing, they shouldn't have any more court proceedings unless, of course, they fail to complete the program, and then they would face a violation.
We'll talk about that in a minute, the violations, but let's go through with the person who does what he or she is supposed to do.
Okay.
It typically takes how long to go through the program? A year?
It's typically a year, yes, but it can exceed 24 months.
Okay, there might be circumstances where someone needs longer than a year?
Yes.
But it absolutely has to be completed within 24 months.
Yes, what happens is at the 11th month of their supervision, if they haven't completed all of their conditions, the probation department will write a violation. But if they have successfully completed them at that point, they can close out the case.
Okay, and then what happens when the case is closed out?
They are sent paperwork. The defendant is sent paperwork from the probation department. It's a letter that they must sign and certify and return to the probation department. That piece of paper is very important because it gets the expungement process rolling. If a defendant doesn't fill out that paper and return it, the charge is going to remain on their record.
Okay, let's talk about expungement. What does that mean?
Expungement means to completely wipe it off your record, as if it never happened.
So if I was an employer checking a criminal record on a potential hire, there are, websites, et cetera, where I can do that.
Mm-hmm.
There are criminal clearance checks, et cetera, where I can do that. If someone was arrested for the crime and was accepted and successfully completed the ARD program, there would be no record of that arrest?
That's correct, no record. Once the expungement process gets started, all record keepers are notified to purge that record up to the Pennsylvania State Police, who then finalizes the expungement, so that as an employer, you get onto the unified judicial system to look up criminal records. You're not going to find that record.
Okay. And but as you indicated, this doesn't automatically happen. After you successfully complete the ARD program and after you receive a letter saying you successfully completed it, you still have to fill out an application for the expungement.
Yeah, essentially it's an application. And what happens is a lot of times defendants think, oh, I'm done. They get that paper, they don't return it. And then 2 years later, they go apply for a job and they call our office and say, what happened? This is still on my record. And the answer is you didn't fill out the paperwork. It's not too late to fill out the paperwork, but that paperwork is what starts the expungement process.
Okay. And that goes into all the records across the state that would indicate that there was an arrest, that would indicate that there was ARD, et cetera.
Yes.
And with respect to this, if it does not count as a criminal record, if someone is charged with another low-grade offense, how do you know whether or not they had a prior ARD?
Well, you're not necessarily going to know unless it was in your county. We keep records, and if the ARD happened in York County, we would see that. But if it happened in Lancaster County, we don't have access to their DA system, so we wouldn't necessarily know that you've had a prior ARD.
Of course, they need to be truthful on the application.
Absolutely.
But if they're not, it could fall through the cracks.
Yes.
But it's my understanding if someone gets ARD once and commits the same, or gets arrested for the same crime later, they shouldn't get on into the ARD program.
Ideally, yes.
Okay. There might be some discretionary
Yes.
circumstances where that can be overruled, but it needs to be reported. But my concern with it is, how do we know if there's no record of it?
Right. And as far as using it against them, if they pick up new charges, if they were to apply for ARD in York County and the offense was in York County, we would still, under our point system, count that as an offense. But as far as going through the normal court proceedings, it may not be counted against your prior record.
For someone to go into ARD, do they admit that they committed the underlying offense?
That's the distinction between the normal court proceedings and ARD, is that it's a disposition. It's not a guilty plea. You're officially placed on ARD. You don't plead guilty into it. So it's not a conviction.
Okay, I understand it's not a conviction, but to qualify for it, do you have to admit you did the underlying offense?
No, you're not standing in front of a judge and saying, I did this.
Okay. So somebody charged with a crime and doesn't want to take the risk of going to trial can still apply for ARD even though they are adamant that they didn't commit the crime?
Yes.
Okay. And what happens if someone doesn't follow the rules, if someone violates the probation?
The probation department will write a violation. The violation will be sent up to the judge. The judge will schedule a hearing, and at that time and date, the defendant will appear, and they can address to the judge why it is they didn't complete their conditions, and the judge would be the ultimate decision maker as to whether they're removed from the program or he gives them an extension.
So if for example, someone did not go through the, you said 70% of the cases are DUI, so I'll use DUI as an example. They need an evaluation, and if the evaluator determines they need to be in some type of alcohol program, and they don't go to it, that would be a violation, correct?
Correct. If they got to their 11th month of supervision and hadn't completed that, the probation officer would write a violation.
Okay. Or if, that would be one example. Another example would be they were driving when they were on a suspended license. That would be a pretty big violation, I would imagine.
Yes. If you pick up new charges, aside from the special conditions of ARD, there's the general conditions. And if you pick up new charges, that is a violation of the ARD.
I see. So if you're charged with another crime while you're on ARD, that's automatically a violation?
Yes, that's a violation.
Even before that you had a trial on the second offense?
The mere police contact is a violation.
You don't need to be proven guilty. It's just being charged is a violation.
Correct.
And then it goes to the judge, and the judge determines whether or not it's serious enough of a violation to remove the person from ARD?
Right.
Now, what happens if somebody is removed from ARD?
Their case will proceed through the criminal justice system. It will be scheduled for a pretrial conference, and they can either plead guilty or take their case to trial. So
in other words, just because you're removed from ARD doesn't mean you have a conviction. You never were tried. You go back to the beginning.
You go back, right.
Basically.
Yes.
And you still have your right to your day in court. You have the right to have a trial. I assume, am I correct, that at the trial, the fact that you were on ARD cannot be made known to the jury? Or,
correct.
It would be irrelevant for what's going to happen with it. The case would have to be tried on the merits of the underlying offense alone.
Yes.
Can the victim, if there is a victim, object or I know of cases where the underlying offense is, let's say, assault, and I believe one of the conditions would be you cannot contact the victim.
Right.
And if they do, this is typically a domestic
yes.
situation. And then that would be the violation.
Correct. If they contacted the victim indirectly, directly, there's two types of no contact orders, but if they violate it, or if they contact that victim, that's a violation. And so
if there is a situation, let's say an assault between husband and wife or boyfriend, girlfriend, and it was a domestic dispute, but an assault charge was filed. The person qualifies for ARD. They're told not to contact the victim during the ARD program. They do. The victim complains. That would be a violation. It would be up to the judge whether or not to take the person off the ARD program.
Correct.
And if the judge takes someone off the ARD program, can that be appealed?
The defendant or defense counsel can file a motion for reinstatement with the judge, essentially asking for them to be put back in, but it's not an appeal.
So you can basically go back to the judge and say, well, you removed this person from ARD. We think, even though he did something wrong, reconsider, basically.
Right.
But you cannot go up to the superior court and say, this person, the judge took me off unjustly.
Right.
And that's my understanding, because this whole process is discretionary.
Right. It's a privilege.
It's a privilege. It's not a right.
Correct.
That's the standard that we use here. We're running out of time. I wanted to point out something that you told me before we began, which is called summary ARD,
yes.
which are for minor summary offenses that would be for district justice. And that's not a statewide or even countywide rule. It varies from district justice to district justice.
Right.
I'm not going to have time to go into that, but just make people aware that it exists. This is Legal Lines. My guest today was Katie Romeo from the York County District Attorney's Office.